Yet the term subject to the jurisdiction, it's almost here, right? I haven't actually thought of this before or seen it discussed, but we have a modern use of the word subject in this context, right? Like subject to penalty, subject to an upgrade on a flight, meaning kind of susceptible to. It could be applied to you, right? Subject to the jurisdiction. But I find the use of the word subject here interesting because it may have had a broader etymological context at the time of the 14th Amendment. I mean, what else? What's another application of the word subject, right? It's as a subject of a sovereign, right? You're a subject of the King of England. You're a subject of the government of the United States. Subject to the jurisdiction would seem to combine both of those concepts. The focus on allegiance continued in the years immediately after the 14th Amendment was ratified. Post-ratification understanding of scholars and the Supreme Court. In the years immediately after the ratification of the 14th Amendment, scholars in this court viewed the jurisdiction clause as extending well beyond children of ambassadors and foreign soldiers, confirming the view that jurisdiction was a term of art referring to a specific type of relationship between the individual and the sovereign. By 1872, just 4 years after ratification, the Supreme Court noted that the phrase subject to the jurisdiction was intended to exclude from its operation children of ministers, consuls, and citizens or subjects of foreign states born within the U.S. That's the Slaughterhouse cases, very famous cases, law school type of case. To be sure, this was likely dicta, meaning not essential to the legal finding in Slaughterhouse and therefore not controlling legal precedent, but it reflected the contemporaneous understanding that the jurisdiction clause was not a narrow exception solely for ministers, consuls, and invading soldiers, but applied also to children whose parents remained citizens of another country. All of these groups had one thing in common: they lacked total allegiance to the U.S. 1 year later, the U.S. Attorney General, who had been a senator during the debates over the 14th Amendment, issued a formal opinion explaining that the word jurisdiction must be understood to mean absolute or complete jurisdiction, such as the United States had over its citizens before the adoption of this amendment. Aliens, among whom are persons born here and naturalized abroad, dwelling or being in this country, are subject to the jurisdiction of the U.S. only to a limited extent. Political and military rights and duties do not pertain to them. Again, note the two different forms of jurisdiction: criminal and political. The next year, the House of Representatives, so this is now 1874, issued a report stating that the United States have not recognized a double allegiance, dual citizenship. By our law, a citizen is bound to be true and faithful alone to our government. So that used to be the law. Could be again. This again equates citizenship with the concept of total allegiance, not merely partial allegiance, nor partial authority by the sovereign over that individual. In 1881, a treatise on citizenship by Alexander Porter Morse adopted the Attorney General's 1873 view, reiterating that aliens, among whom are persons born here and naturalized abroad, dwelling or being in this country, are subject to the jurisdiction of the United States only to a limited extent, and thus their children would not be citizens. Contemporary scholars further confirmed that jurisdiction had two meanings, one limited and one more complete. In 1881, Treatise on the Conflict of Laws, recognized that in one sense, a child born in the U.S. is necessarily subject to its jurisdiction in the simple sense that all foreigners are bound to a local allegiance to the state in which they sojourn, at least allegiance to its criminal laws. Yet the term subject to the jurisdiction, it's almost here, right? I haven't actually thought of this before or seen it discussed, but we have a modern use of the word subject in this context, right? Like subject to penalty, subject to an upgrade on a flight, subject meaning kind of susceptible to. It could be applied to you, right? Subject to the jurisdiction. But I find the use of the word subject here interesting because it may have had a broader etymological context at the time of the 14th Amendment. I mean, what else? What's another application of the word subject, right? It's as a subject of a sovereign, right? You're a subject of the King of England. You're a subject of the government of the United States. Subject to the jurisdiction would seem to combine both of those concepts. Yet the term subject to the jurisdiction must be construed in the sense in which the term is used in international law as accepted by the U.S. as well as in Europe. And by this law, the children born abroad to American citizens are regarded as citizens of the U.S. with the right on reaching full age to elect one allegiance and repudiate the other, such election being final. The same conditions apply to children born of foreigners in the U.S. And it needs to be final, right? This election, because a particular crime that sovereign states are concerned about is what? Is treason. But treason is only treason if it's committed by a citizen. If it's committed by a foreign national, it may be some other crime, but it's not treason. Treason is, an offense against one's own nation. George Collins, who was later appointed amicus in the Wong Kim Ark Chinese national case, explained in 1884 that the phrase subject to the jurisdiction thereof does not mean territorial jurisdiction, but it means national jurisdiction, that it is the jurisdiction which a nation possesses over those who are its citizens or subject as such. In 1884, this Supreme Court decided Elk v. Wilkins, I mentioned that earlier, which held that Indians were not citizens under the 14th Amendment because they owed allegiance to their tribes. The Supreme Court held that the evident meaning of the jurisdiction clause was that a person was not merely subject in some respect or degree to the jurisdiction of the U.S., but completely subject to their political jurisdiction and owing them direct and immediate allegiance. Moving beyond the context of Indians, the Supreme Court explained that the 14th Amendment would confer citizenship only on those children whose parents are owing no allegiance to any alien power. But an immigrant from any foreign state cannot become a citizen of the United States without a formal renunciation of his old allegiance and an acceptance by the United States of that renunciation through such form of naturalization as may be required by law. Again, note the concepts of total allegiance by the individual and an acceptance by the United States. Two-way street. Jurisdiction and the jurisdiction clause invoked that reciprocal relationship. In lectures posthumously published in 1891, Supreme Court Justice Samuel Miller explained the jurisdiction clause extended beyond mere ambassadors. If a stranger or traveler passing through or temporarily residing in this country who has not himself been naturalized and who claims no allegiance to our government has a child born here which goes out of the country, which is with its father, such child is not a citizen of the United States because it was not subject to its jurisdiction. So that's the Wong Kim Ark case. Given this body of evidence, modern scholars have recognized that there was a significant agreement among contemporary legal scholars and executive branch officials during the same time, including secretaries of state, that the jurisdiction clause invoked the concept of total allegiance to the United States. As long as the parents remained citizens of a foreign country, their children born in the United States could not be U.S. citizens. And that was especially clear where the parents' home country would confer citizenship on those children, so they're not stateless, meaning they were subject to their parents' home country even at the time of birth. They were not stateless like the freed slaves were stateless, which is what the 14th Amendment was for. That explains why such children themselves had, at the best, divided loyalty. They were claimed as subjects by their parents' home country, meaning they could not owe total allegiance to the U.S. Oh, and we get Wong Kim Ark. Plaintiffs, the people who want the universal birthright citizenship, and the unelected, black-robed, tyrannical, inferior district trial courts below chiefly relied on this Supreme Court's decision in U.S. v. Wong Kim Ark, 1898, but their reliance is misplaced because the Supreme Court, tied allegiance to whether the U.S. had permitted or consented to the parents being permanently present in the U.S. at the time of their child's birth. Illegal aliens, by definition, are not present with the consent of the U.S., and accordingly, it makes little sense to argue that Wong Kim Ark dictates citizenship for their children. Wong Kim Ark involved a person who was born in the United States to alien parents who, at the time of the child's birth, enjoyed a permanent domicile and residence in the U.S. with the sovereign's permission, our national permission. The Supreme Court held that such a child becomes at the time of his birth a citizenship of the United States. Invoking the old concept of allegiance, the Supreme Court held that foreigners present in the U.S. are entitled to the protection of and owe allegiance to the U.S. so long as they are permitted by the United States to reside here. Continuing with the theme of sovereign consent as an aspect of allegiance, the Supreme Court held it was incontrovertible that the jurisdiction of every nation within its own territory is exclusive and absolute, and may only be qualified by the consent, express or implied, of the sovereign. That traced or followed, aligned with Chief Justice Marshall's opinion in the Schooner Exchange, which addressed the rights of Americans whose ship had been seized at sea by Napoleon's agents and then sailed into Philadelphia under a French flag. Echoing language later found in the 14th Amendment, the Supreme Court held that the jurisdiction of the nation within its own territory is necessarily exclusive and absolute, and thus all exceptions to it must be traced up to the consent of the nation itself. Birthright citizenship could not be gained by the sovereign, from the sovereign, by those present in defiance of its laws. I see we got a handful of super chats. Let me see how far I have to go to the next section. Not very far. Let me finish this out, and then we'll pause this and I'll hit the super chats. Wong Kim Ark concluded that foreigners owe the requisite allegiance when the United States permits them to be here permanently, permanent residents. One need not decide whether Wong Kim Ark was fully correct on that score. I believe it was not, because the test it imposes still resolves the question here, because Trump's executive order does the same thing. It allows citizenship for children born to permanent resident aliens. By definition, illegal aliens do not have consent to be here, are not permitted to reside here, nor have they been given permanent domicile and residence in the U.S., as were the parents, Chinese national parents of Wong Kim Ark. The executive order at issue here notably excludes children of lawful permanent residents, so they continue to get birthright citizenship, which is the modern equivalent to the parents in Wong Kim Ark. The Supreme Court's opinion in Wong Kim Ark extends no further. It grants birthright citizenship. The executive order and Wong Kim Ark both grant birthright citizenship to children born on American soil to American parents and children born on American soil to permanent resident aliens. That's the proper understanding of the current law. I think Wong Kim Ark should be reversed because I think it made something up. And the courts are not supposed to make up law. The 14th Amendment doesn't say it applies to permanent resident aliens. So I don't see the authority that the Supreme Court, remember, only Congress can grant the terms of citizenship. Supreme Court can't do it. But even if you think Wong Kim Ark is correctly decided, Trump's executive order on birthright citizenship aligns with it perfectly. The universal birthrighters rely on a few broad statements in Wong Kim Ark, but ironically, the opinion itself cautioned against relying on such statements. Quote, "It is a maxim not to be disregarded that general expressions in every opinion are to be taken in connection with the case in which those expressions are used. If they go beyond the facts of the case, they may be respected, but ought not control the judgment in a subsequent suit when the very point is presented for decision." So this is referring to a concept we now call dicta. Dicta is a passing phrase in a court decision that is not material to the legal question in the case. This happens all the time. There'll be a specific legal question, and the court will write about that question, and then the court just meanders and talks about other things that are not material to the legal question before it. That is not controlling legal precedence. It doesn't have controlling legal authority. The stuff that is material to the legal question in dispute does have precedential value and is binding in other courts. But the stuff that is just passing remarks does not. And the thinking is that if an issue is key, is material to the legal question being disputed, it's being very rigorously thought about and fought over. So it's being rigorously tested. A passing remark that's not material to the case, everyone's like, who cares? Why bother challenging that? It doesn't matter in this case. That's dicta, and that has no precedential value. Continuing here, accordingly, until recently, circuit courts across the country had long read Wong Kim Ark narrowly in light of its specific facts, narrowly applying to permanent resident aliens. One final note, Justice John Marshall Harlan, the patron of interpreting the Constitution as colorblind, and the sole dissenter in Plessy versus Ferguson, the since overturned Supreme Court decision that held that slaves could not be American citizens. Harlan dissented from that, joined Chief Justice Fuller's dissent in Wong Kim Ark, arguing that Wong never became and is not a citizen of the United States. That is, to my mind, folks, the correct decision. I wonder what the voting was on Wong Kim Ark. I actually don't remember. 6-2. 6-2. So a super majority. Not somebody must have recused because they don't have 9 votes there. Or maybe somebody was dead. Who knows? But there were 2 dissenters, Marshall Harlan and Chief Justice Fuller. Clearly, Justice Harlan viewed that position as fully consistent with our nation's commitment to equal protection. In other words, that the 14th Amendment applied to those born on American soil, to American citizens, and the freed black slaves, but not to anybody else. Not to anybody else.